I'm Jeb Butler. This is Matt Kahn. We're the lawyers at Butler Kahn. We recently resolved a case for $3.5 million at mediation. And you know, every personal injury case is hard and has its own challenges, but this is a sexual abuse case, which makes everything a little bit more emotional and a little bit even more complicated. So it's one we were glad we were able to get resolved. We felt good about our chances at trial if we had to do that, but for our client's sake, we were happy to get it resolved. Matt will tell you about the basic facts in just a second, but we're a little bit limited by confidentiality. Sometimes when a case settles, the parties agreed that certain things have to be kept confidential, particularly in cases like this, so we're a little limited in what we can say. But Matt, what happened?
Sure. So we represented a 16-year-old teenage female who worked at a fast food restaurant, and she was sexually assaulted by her supervisor, not once but twice. And so the case really focused on proving that the assault happened, and then proving that the fast food chain knew about this supervisor and should have done something to protect the young girls that worked at the store.
Yeah. And a lot of people, when they think about a case like this, think about the police and the prosecution of the assailant, and you know, that's a part of it, but for our purposes, it's not really enough. In order to hold the fast food chain liable, we have to show that its managers either knew or should have known that there was a danger from this assailant, from the person who actually, you know, did the attack here, and or we have to show that the management knew or should have known that this was a dangerous workplace, basically that something like this could happen. And that's a hard thing to prove because they ain't ever going to admit it.
Right.
So, Matt, what do we do?
Yeah, so this is a great example of the importance of just talking to people, talking to witnesses. And so through knocking on doors and talking to former employees, we were able to identify 5 or 6 people who had worked there and had problems with this guy, this assailant. And when you're in an environment like that, people are generally going to be eager to get this burden off of their chest, and so we had a lot of very good witnesses. One of the most powerful of which was a manager at the restaurant who gave us a great affidavit that really moved the dial on the case. So we've got it pulled up here, and we essentially met with this manager at the restaurant who had not only noticed the misconduct, but he convened a meeting to warn young women that worked at the store that this other supervisor was a sexual predator, and told all of the employees to keep an eye out for this employee. But the restaurant didn't do anything, and that's why the sexual assault happened.
I mean, this is pretty wild. We've looked at a lot of cases, but it's pretty rare. You know, Matt talks about them being eager to come forward. Matt did a great job finding 5 or 6 people who had worked here who were willing to speak on the record and give us sworn testimony, either in their deposition or in writing, like we see on the screen behind us now, of what had happened. But this is really remarkable. This manager had not only known about the problem, but convened a meeting, and we got sworn written testimony and an affidavit about that here. We won't go through the whole affidavit, but it goes on into the culture of sexual misconduct at that restaurant. I mean, it was pretty powerful evidence. So we gathered all that evidence. It goes before the court in motions, and then we ended up at mediation. I cannot now recall if the court ordered mediation or the defense asked for it. I think it had been both. The defense asked, and then the court ordered, and we were like, all right, we'll go. So we went to mediation, swapped numbers back and forth. We were able to come to an agreement with some confidentiality protections such that our client has those protections, as does the defendant. But the case settled for $3.5 million.